afternoon. My name is Sue Jarvis and I'm co-director at the Heseltine Institute for Public Policy, Practice and Claims here at the University of Liverpool. And I'm delighted to welcome you all today to our Heseltine Institute annual lecture. For those of you who don't know the Heseltine Institute, we're the university's city-facing public policy institute and thought leader. And we have a remit to bring together expertise from across the university and policy communities to co-create, impact upon and influence public policies for tomorrow's cities. So the university recently launched a new strategy, Liverpool 2031, which sets out our strategic ambition to break into the top 100 ranked universities worldwide in time for our 150th anniversary in 2031. And one of the key areas of focus, place and innovation, outlines a commitment to working with partners to drive prosperity and well-being in the Liverpool City region. And it is here where the Heseltine Institute can play a leading role by supporting and influencing the development of sustainable, inclusive cities and city regions. And we know that the policy context facing local and regional leaders is increasingly one defined by uncertainty. Amidst mounting political, social, economic and environmental crises, what can local governments do to maintain a sense of strategic stability and resilience alongside the need for policy dynamism and rapid innovation? The Institute's policy briefing series, focused on the theme of policy in an age of uncertainty, seeks to address this challenge, designed to inspire, provoke and prompt action on a host of pressing policy challenges and choices facing cities. These briefings foster collaboration between researchers and policymakers. And in keeping with this intention, we are delighted that the University of Liverpool's new Chancellor, Judge Wendy Beetlestone, will give this year's Heseltine annual lecture. My colleague and fellow co-director at the Institute, Professor Catherine DeRose, will introduce Judge Wendy. But before we get started, I will first hand over to the University's Vice Chancellor, Professor Tim Jones, who will say a few words of welcome. Tim.
Thanks, Luke. Thank you, Sue. I really won't speak very long. Really, I just want to welcome you all to a lovely setting, actually. It's the first time I've been in this building, so it's a really nice theatre. And thank you for coming this evening. I also want to thank Sue and Catherine, the co-directors of the Heseltine Institute, for the work, and then the teams for the work they put into to organise this event, which is fabulous. Thank you to you both. And finally, just to welcome Wendy Beetlestone, our Chancellor. Wendy, over all the degree ceremonies we're running at the moment, and thank her for giving this lecture as well. So I'm sure it'll be a very stimulating evening. I'm sure she'll provoke lots of interesting thoughts and discussions. And I do hope you all enjoy it. So thank you once again for coming. Thank you.
Hello everybody, I'm Catherine DeRose, Professor of Public Policy and Co-Director for the Heseltine Institute. As you're aware, our speaker for this evening is the Chancellor of the University of Liverpool and United States District Judge Wendy Beetlestone. Appointed earlier this year, Judge Beetlestone is the University's 11th Chancellor and the institution's first female and first black Chancellor. An alumna of the university, Wendy was born in Jai, Nigeria and educated in Yorkshire. She graduated with BA Honours in Philosophy in 1984 before embarking on a career in journalism, entering the legal profession a decade later. In 2014, she was nominated by US President Barack Obama to serve as a district court judge, and her jurisdiction covers both civil and criminal cases involving US Constitution, US statutes, and diversity cases between citizens of different states. We are delighted that Judge Beetlestone has chosen the annual Heseltine lecture for her first lecture here at the University of Liverpool since her appointment as Chancellor. Judge Beetlestone will speak on the theme of upholding justice, the importance of judicial independence in an age of uncertainty. As policymakers face unprecedented challenges of uncertainty, complexity and contestation, Judge Beetlestone will use the lens of judicial independence to reflect upon the important role of public institutions in meeting these challenges. Judge Beetlestone will speak for just under an hour and then we will have time for conversation and discussion with you all. Thank you. Please may I welcome Judge Heseltine.
you, Sue. Thank you, Catherine, and thank you, Tim. The title of my presentation today, and tell me if you can't hear me because I have a very quiet voice. Good. I'm used to just going like this in the courtroom, and people will be quiet. So I will try and raise my voice. The title of my presentation today, which is Upholding Justice, the Importance of Judicial Independence in an Age of Uncertainty, holds within it the structure of the talk I'm about to give. The title also contains some fairly significant assumptions. Assumption one, that this is an age of uncertainty. And I'm going to take that as a given here, although I think there is room for debate as to whether our days are more uncertain than other turbulent times in history. Assumption two, it is important for the judiciary to be independent. For the record, I define judicial independence to mean the ability of a judge to make decisions based on the facts presented and the applicable law alone, in the context of an accepted rubric of jurisprudential interpretation, without facing political or personal consequences. Assumption three, that there are ways to uphold justice even in an age of uncertainty, so long as we ensure that judges can exercise their function in an independent fashion. And I'll confess to you up front that that is not only the trickiest, but also the most pressing of issues I address today. Underpinning these assumptions is the question of why they are relevant in a lecture sponsored by the Heseltine Institute, which seeks at its core to offer informed contributions on matters of urban policy. I hope during the course of this talk to unpack some of the assumptions and shed some light on how any focus on urban policy must necessarily include consideration of judicial decision-making. Much of my focus will concern United States legal precepts and principles because that is what I know best. But they, I think, are equally applicable here in the United Kingdom, given the commonalities of our two nations. You no doubt have read or heard about concerns that democracy is in decline around the world. The reports often stem from a concern that the rule of law, which many believe to be the foundation of a strong democracy, is eroding. But what is the rule of law? There is no universally recognized definition, but the phrase tends to include government limited by law, equality under the law for all citizens, protection of human and civil rights. The guardianship of the rule of law sometimes falls within the domain of the legislative branches and requires open government such that a country's citizens have pathways for participation in government, and the government responds to the needs of its citizens. Usually that is achieved through fair elections, through a means of petitioning one's government, and responsive representatives, senators, members of parliament. In addition, we are reliant on the lawmakers to enact just laws. But other principles that underpin the rule of law fall squarely within the bailiwick of the judiciary. Accountability, determining who has violated criminal laws and civil laws and what should be done about it. In the criminal context, is the prosecution valid? Is the defendant getting the process that is his or her due? What sentence is warranted if the defendant is found or pleads guilty? In the civil context, it is managing the docket to ensure the efficient administration of justice through motion practice and trials. My civil and criminal dockets both frequently require me to review laws to determine whether they are compatible with fundamental legal protections and to determine if or how they apply to the dispute before me. It's the bread and butter of what I and my colleagues do every day. In that role, the judiciary provides a check on legislative and executive power, upholding human rights, providing oversight against corruption, buffering against arbitrary and unchecked power. In addition to accountability, accessibility to justice also falls to a large extent within the judicial branch. The ability of people to obtain remedies for wrongs that have been done to them through an understood and formal process, the availability of legal representation, lawyers, and if an individual or entity is representing themselves, a means to progress through the system. Accountability, accessibility, transparency is the third one. And transparency in judicial proceedings can fall in several areas. Open courts, open courtrooms. So, for example, as a law student, I wanted to see an argument before the United States Supreme Court. I went down to Washington, I lined up, I had no idea what argument was going to occur, and got in, got my seat, heard all about riparian rights in the West. And if any of you would like to hear more about riparian rights, they are fascinating. We can have a chat afterwards, but I'm not going to talk about them right now. Nevertheless, I did thoroughly enjoy my time hearing an argument before the Supreme Court. And, or, as I have done on occasion in coming to London, I walk into the Royal Courts of Justice and hang a while in the public galleries to listen to whatever matter is being heard in the courtroom that day. And everyone can do that. Line up, walk in, watch justice in action. Transparency also requires that opinions are written in a fashion that can be understood by lay people as well as those in the law, and that are made available to the public. I aim to write opinions that are jargon-free, written in as plain language as possible, so that they can be understood by the parties, by any appellate court that is asked to review the opinion, by the bar, by the media, particularly if it is a matter in which they have expressed interest, and by any member of the public who cares to read them. This transparency is central to educating citizens that impartial justice, the notion that every person who appears before a court is entitled to be treated in a fair, respectful, and unbiased manner, is at the core of judicial decision-making. These notions of accountability, accessibility, and transparency are central to the judiciary's contribution to the balance of power, and central to the public's trust in the judiciary. However, across the world, there are examples of how incursions on democracy are being reinforced by an erosion of judicial independence. Or, some might argue, the erosion of judicial independence is on the leading edge of incursions into democracy. Often, the challenge to judicial independence comes from other branches of government, the executive or the legislature, and is in essence a power grab. For example, in Tunisia, a democratically elected president announced that he would dissolve the High Judicial Council and shut down the Supreme Court building, preventing the judges from doing their jobs. He then dismissed 57 judges. In Poland, the government has passed laws that have brought the judiciary under political control. Judges who rule contrary to the government can face disciplinary measures. In Guatemala, anti-corruption judges and prosecutors are jailed. Judges in the Court of High-Risk Crimes are physically intimidated and threatened with the loss of their judicial immunity. In Israel, efforts to restrict the power of the Supreme Court met with demonstrations across the country. Similarly, attacks have been made in Hungary, in Romania, in Turkey, in Myanmar. The list goes on. In other instances, the threats are to individual judges made by criminals. So, for example, in Mexico, Italy, Serbia, judges handling criminal cases involving conspiracies and cartels have been threatened and assassinated. But lest we think that the United States and the United Kingdom is exempt from these threats, we are not. Let's talk first about the United Kingdom. There is a tradition in Britain of judicial independence. In 1761, King George III, in a speech respecting the independence of the judiciary, affirmed that judicial independence is essential to the rights and liberties of British subjects and is most conducive to the honour of the Crown. 2 centuries and a half later, the Constitutional Reform Act of 2005 recognises the continued importance of an independent judiciary. But a recent inquiry into judicial independence by the All-Party Parliamentary Group on Democracy and the Constitution concluded that ministers have publicly attacked judges by misrepresenting judicial decisions or threatened political reforms of the justice system, apparently in response to judges ruling against them. According to the report, in doing so, they have failed to act in a constitutionally proper or helpful manner. The constitutional safeguards, which should protect the independence of the judiciary from pressure by the executive, according to the report, has been eroded. In particular, it concludes the offices of the Lord Chancellor and Attorney General have become politicized. Where these offices were previously held by senior and well-respected lawyers, with the independence to speak up for judges when their ministerial colleagues acted inappropriately, they are now often held by politicians. The report went on to note that the vast majority of judges expressed serious concern about the then current state of affairs. In fact, 94% were concerned or extremely concerned about the government's conduct towards the judiciary. It concluded that the government's conduct and the recent alleged pro-executive turn in Supreme Court decisions may create an impression that the Supreme Court has been influenced by government pressure. And as I told you, neither is the United States exempt from challenges to judicial independence. At least with respect to the federal judiciary, of which I am part, there are constitutional safeguards in place to protect judicial independence. I have life tenure. No one can remove me. There is no reduction in my salary. In fact, my salary has to go up by a cost of living increase every year. I can be removed only for high crimes and misdemeanors after a process through the Senate. The Supreme Court of the United States in 1803 clearly established that it is the independent judiciary's responsibility to protect the people from the overreach of the other 2 branches, the executive and the legislature. But unpopular decisions by a judge can and do have direct results. Individual judges increasingly face challenges through the media and through social media outlets, which have escalated into death threats. In fact, threats against the federal judiciary has spiked more than 400% in the past 6 years, 3,700 threats in 2022 alone. Quite apart from the threats, further perceived ethical lapses by Supreme Court justices, as well as sea changes in jurisprudential norms, which I'll talk a little bit more about later, have led to more than half of Americans losing trust that the Supreme Court is operating in the best interests of the American people, but rather that they rule in a partisan fashion, in that they behave as politicians rather than judges. Now, one could argue that it is right to challenge unpalatable decisions of the judiciary, because judges are, after all, often unelected figures whose decisions have a huge impact across our societies. And so if they do something we do not like, we should be able to hold them account. Certainly, it cannot be denied that judicial decision-making can and has shaped our societies in significant ways. One example in the United States of how the Supreme Court has shaped policing in America, particularly in the cities, is found in how it has analyzed the Fourth Amendment to the United States Constitution in the 200 and some years since it was enacted. Let me tell you what the Fourth Amendment says. It says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The goal of the Fourth Amendment is to protect people's rights to privacy and freedom from unreasonable intrusions by the government. It embodies the notion that every person has the right to retreat into their home and there to be free from governmental intrusion. In other words, an Englishman's and an American's home is his or her castle, their property. In enacting the Fourth Amendment, the founders of the United States drew from the hostility to writs of assistance, which were widespread at the time. They were general search warrants issued by British courts sitting in pre-revolution America that empowered customs officials to combat smuggling. Agents did not need to obtain individual search warrants each time they sought to conduct a search, but instead could freely search vessels and homes without probable cause or express permission. They have recently, in fact, been described by the Supreme Court as a practice that inspired the revolution and became the driving force behind the Fourth Amendment. In the face of a changing society, the Supreme Court of the United States has struggled mightily to determine what is a search under the Fourth Amendment, which requires a warrant, and what is not a search under the Fourth Amendment, which does not require a warrant. The implications for policing in the United States have been enormous. For example, in the midst of prohibition, a time in the 1920s when intoxicating liquors were banned in the United States, shining a deck-mounted spotlight onto the open deck of a vessel used for rum running did not constitute a search. And in fact, even today, that does not constitute a search. For years, no warrant was required for thermal imaging of property. In essence, if pot is grown in a building, it emits heat, which can be seen through a process of thermal imaging. But in 2001, the Supreme Court required that a warrant is required. To what extent investigators can listen into phone calls has changed over time. Before telephones became ubiquitous, police were allowed to listen in on phone calls. But after they became more commonly used, the Supreme Court determined that a search warrant was required to intercept communications from a phone booth. And more recently, the Supreme Court has clarified that cell phones cannot be searched routinely incident to arrest. Also, people have a reasonable expectation of privacy in their physical movements as captured by cell site location information. Nevertheless, there is no need for police to obtain a search warrant for search of a pen register. And a pen register essentially produces a list of phone numbers and internet addresses that you've contacted, but doesn't include the substantive information pertaining to those numbers and those internet messages. As you can imagine, the work of law enforcement officers in the United States, particularly in urban areas, has been driven by these decisions. In many of my criminal cases, the defendants file motions premised on the Fourth Amendment, arguing that the investigation of their matter by police involved an unreasonable search and seizure, and that accordingly, some evidence should be suppressed, i.e. not used at trial, or that some charges, or often the entire case, should be kicked out. In several cases, I have granted such a motion. None of the Supreme Court Fourth Amendment cases have had more far-reaching impact on urban policing than Terry versus Ohio, which the Supreme Court, while recognizing the Fourth Amendment concerns, sanctioned or approved the police practice of stopping people on the street without a warrant based on reasonable suspicion and frisking them for weapons. So-called stop and frisk shortly became associated with race discrimination on the part of the police. Eric Garner, a black man, died after police stopped him under the stop and frisk rubric. They had him in a chokehold. His final words were, "I can't breathe." George Floyd, also black, also died after being stopped and held down by police. Among his last words were, "Mama, mama, mama. Tell my kids I love them. They gun kill me. I can't breathe. Please, sir, please, 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 I can't breathe." Both deaths were caught on camera, and both became a catalyst for demonstrations across the country. I use that trajectory regarding how courts have interpreted the reach of the Fourth Amendment as an illustration of the importance of judicial decision-making and the impact it has on the body politic. It makes clear that despite the rarefied air in which they are made, judicial decisions can have wide-ranging political and policy consequences. But there is a critical distinction to be made between opinions that have such consequences and opinions that are made on the basis of politics. In other words, judicial decisions which have political or policy consequences are not the same as political decisions. And it is the role of the courts, of judges, to ensure that the wall between the two remains in place. In making decisions, the touchstone is that disputes must be determined in accordance with the facts before the court as informed by the law. Personal viewpoints have no role in the process. Acknowledged and implicit tendencies or biases must carefully and intentionally be put aside. That is bedrock. And you would be hard-pressed to find a judge who would not, if asked, tell you that they hew to that proposition. There is, however, concern brewing, perhaps boiling, or at least simmering, in the United States, that while judges themselves remain neutral, new forms of judicial interpretation of the Constitution and of statutes have introduced instability and a political bent into the system. In order to understand that new prism, it's first necessary to take a high-level look at the traditional methods of judicial interpretation in the United Kingdom and in the United States. There are various canons of construction used to evaluate how words and phrases in a provision should be read to arrive at a coherent interpretation of a particular provision. The starting point is the words of the provision at issue, their plain meaning, any definitional sections in a statute, the provision's context and structure, how other words and other phrases in the statute relate to the one at issue. Apart from these canons of construction, there's always been some debate as to whether one should look to natural law, and therefore moral precepts, and therefore religion, and therefore which religion, to figure out how things should go. And generally, as new and previously unknown issues have been presented to the courts, most recently, for example, the internet, social media, and now cryptocurrency, the law has incrementally borrowed from the old rubrics to fashion means of dealing with the new situations. In the United States, most notably at the Supreme Court level, these traditional rules of interpretations are now being augmented, particularly in the constitutional context, by what has been dubbed originalism. Originalism is based in the belief that a text should be interpreted to comport with the understanding of those who wrote it. For example, to interpret a constitutional provision put in place by the founding fathers of the United States, one has to look to what they would have understood it to mean. Rather than view the provision in the context of the world as it is today, one looks to what a person in the late 18th century might have thought it to mean, what they wrote about the words they adopted, what the words meant at the time they were adopted. There is a huge debate about the validity of originalism. For example, people say, originalism doesn't make sense, and what's wrong with the tools we've been using all along? Each generation should decide what the Constitution means, and through the ages we have done so. Accordingly, why do we need originalism? The flashpoint around its usage is that it is viewed by some as a cover for a right-wing political agenda. And it could be argued that this viewpoint has some traction. Recent Supreme Court decisions have relied heavily on an originalist perspective to allow citizens to carry weapons in public as a matter of constitutional law to undo a woman's right to choose. Dicta is something that isn't decided by the court, but the court says something, and you can use it in future decisions, maybe. That wasn't a very good explanation, but essentially dicta is not a very good explanation. But essentially dicta in an opinion written by a Supreme Court justice suggests that it could be used in the future to target gay marriage and other LGBTQ rights and to foreclose access to contraception by women. As the justices refine originalism as a means of interpretation, its approach becomes more granular. As relevant here, the focus has now turned to a new tool, new at least to the judiciary, that is historical analogy. Interpretation by historical analogy looks for the meaning of a constitutional provision not only into the minds of the founding fathers when they adopted the Constitution, but also to the historical realities of their break from England, the laws that were enacted and in place at the time, and the laws of England pre-revolution. Now let me put this new tool, historical analogy, into context. Although the distinction between what the founders thought of the contours of the Fourth Amendment is starkly different than what we think they are today, the changes have been made over 200 years using traditional rules of constitutional interpretation. Further, we know when Congress models a statute on an existing one, courts often look to the text, structure, and history of the first law to construe the scope and operation of the second law. Because interpreting statutes in light of their earlier models is a common practice, outcomes are more predictable, and parties can confidently expect courts to consistently apply analogical metrics and select levels of generality. The process is deliberate and incremental and rooted in existing rules of interpretation. But the introduction of historical analogy into that mix blows the model apart. As an illustration of that point, I will use a recent Supreme Court case concerning the Second Amendment, the constitutional provision that concerns the ownership of guns. And it's a case called New York State Rifle and Pistol Association versus Bruin. It was handed down in 2022. At issue in that case was the application of a statute called 18 U.S.C. 922G1. 922G1 is a statute which makes it unlawful for someone who has been convicted of a felony to carry a gun for the rest of their lives. Up until recently, 922G indictments were routine and for the most part resulted in a guilty plea. But Bruin held for the first time that the Second Amendment right to keep and bear arms for self-defense extends outside the home. And to the extent that a statute regulates conduct protected by the Second Amendment, it is constitutional only if it is supported by analogous historical laws. I would argue that the notion of applying historical analogy to evaluate constitutional questions is highly novel. Under the new interpretive rule of historical analogy, the constitutionality of 922G, at least as applied to the right of a felon to bear arms, rises or falls on whether there is a historical analog from the time of the founding of the United States, either in America or in Britain, which so regulated the right to carry arms. In other words, in its starkest forms, would the founding fathers have taken away the right to own a weapon from someone in the defendant's position? This mandate that judges engage in historical analogy, it introduces puzzling complications into the work we do. Judges have not in the past routinely used historical analogy as an interpretive tool, and it is not self-evident how to do it right. We engage in legal analogy on a fairly regular basis, on a day-to-day basis, using tools developed over hundreds of years. But it is difficult, absent those hundreds of years of precedents and guidance, to even begin to engage in a reasoned process of historical analogy. What does it mean to engage in reasoning by historical analogy? In which time frame does the appropriate historical analogy fall? The 5 years before and after the founding of the United States? But perhaps that is too short. Maybe 20 years on each side of the Declaration of Independence. Maybe 30? The Supreme Court has provided little robust guidance. Do we compare distinctly or relevantly similar aspects of putative historical analogues to the challenged regulation and determine whether the two are analogous enough. But how are we to determine what is similar to what? What is the rubric we are to apply? And what is the proper level of generality to apply? An example, in the early days of the United States, perceived enemies of the state were not allowed to carry weapons unless and until they swore allegiance to the United States. The theory for this regulation was that enemies of the state are dangerous to the state. Now, if one were to use that regulation as the underpinning historical rationale for gun control regulation in 2023, it could be read along a continuum in a variety of ways. Either it could be read to say that taking away guns from all enemies of the state is okay. Or it could be taking away guns from enemies of the state only if those enemies are dangerous to the continued existence of the state is okay. Or it could be read to be taking away guns from anyone who is dangerous either to the state or to the physical well-being of another, or perhaps even to themselves, then it's okay to take away their weapons. Without meaningful criteria to evaluate why any dissimilarity is relevant or not relevant, and which level of generality is to be employed in coming to a decision, we are in a bit of a pickle. And that is a legal term of art. And at least of yet, we do not have a body of law to guide us on that question. And if historical analogy is adopted more broadly as an analytical tool, the problem seeps across the jurisprudential landscape. Getting history right is difficult. Indeed, the Supreme Court has recently seemingly got it wrong. And this is because, I say this because of some work of some British historians. The case I want to talk about is a case called United States versus Gamble. This is a 2019 case. The defendant was convicted under an Alabama law for possession of a firearm as a felon. The United States then prosecuted him under 922G. That's the statute I was just talking about. Defendant moved to dismiss the federal indictment on the grounds that it was for the same offense that underpinned his state conviction and thus exposed him to double jeopardy in violation of the Fifth Amendment. The motion was denied. The defendant pled guilty, but reserved the right to appeal from the denial of the motion, and the matter reached the Supreme Court, which held that the double jeopardy clause of the United States Constitution allows for successive prosecutions by sovereign bodies. In other words, someone who does something illegal can be convicted twice for the same actions, once by the state and once by the feds. The majority opinion provided several rationales for its decisions, but a key ground was based on the court's use as a historical analog of early English case law. It believed it had found a relevant matter concerning the prosecution in England in 1677 of a man named Hutchinson. Now, Hutchinson had murdered someone in Portugal, but having been jailed, he was acquitted twice. He was very well connected in Portugal. He returned to England, and upon his return to England, he was imprisoned again on suspicion of the same murder in Portugal. The Supreme Court in Gamble could only find indirect and shaky, and that is, quote, indirect and shaky accounts of what happened to him. But it read those indirect and shaky accounts to conclude that there is not one reported decision barring a prosecution based on prior trial under foreign law. Shortly after the case was decided, two British professors dug into British archives and found to the contrary. They wrote a detailed article about their findings, which concludes with these salient points. First, English courts have long cited the Hutchinson case as authority for the proposition that an acquittal abroad acts as a complete bar to a prosecution, just as if the acquittal had been in England. Second, if the United States Supreme Court is true to its originalist claim, and this is the English professors, it should review Gamble. In other words, the Supreme Court's understanding of Hutchinson was wrong, and if its decision in Gamble was premised on its incorrect understanding of Hutchinson, then its decision in Gamble was wrong. To extrapolate, and then perhaps Gamble would not have been convicted under a federal statute as well as a state statute, which federal statutes generally carry a longer prison sentence than state statutes. Now, at this point, it is almost certain that the Supreme Court will not reconsider its decision in Gamble. But it is an example of historical analogy, an untested, novel methodology of legal interpretation now being increasingly embraced by the Supreme Court majority, which can be problematic. So I return to a question I asked at the beginning of the lecture. What is the impact of judicial decision-making on urban policy, and why does it matter? More specifically, why does it matter in the context of the Heseltine Institute annual lecture, which aims to address important and topical issues of urban policy? That, with a thematic focus which reflects a sense that we are living through an era of political polarization, intense value contestation, where stakes are high and issues urgent. Well, as you have heard, judicial independence, which, as I have discussed, can be eroded by external forces as well as internal straying from tried and true principles of legal interpretation, self-inflicted judicial wounds, if you will, has a direct bearing on what happens in our world, in our countries, and in our cities. I'll start with USA examples and move to British examples. In the United States, let's return to 922G. Now you know all about it. Nearly 19 million Americans, a little over 17% of the entire population, has a felony record. In a country where gun rights are protected and any limitations on the right to bear arms is fiercely resisted, lifting 922G restrictions has broad implications. The stakes are high. For the felons, many of the defendants charged under 922G live in dangerous neighborhoods and feel that they must carry a gun to protect themselves, or others would say, and their turf. But in Philadelphia, where I live this year, as of 2 weeks ago, there were 1,213 victims who had been injured by gun violence and 348 people who had been killed. Political polarization and value contestation. One side of the policy debate would say, keep our streets safe. Once a felon, always a felon. Why allow guns to people who are likely to use them in criminal activities? There's a civic virtue theory. Those who break the law have shown that they lack civic responsibility and therefore should not be qualified as a person who has a right to bear arms. But on the other side of the policy debate, once a person has paid his or her debt to society, why continue to punish them by depriving them of a constitutional safeguard, the right to bear arms? Many felons were convicted of non-violent offenses. Since they never committed violent crimes in the past, why assume that they are going to do so in the future? There are many examples in the United Kingdom that have either worked their way through the system or are working their way through the system now. Brexit is an obvious example where ministers were at loggerheads with the judiciary over an issue that had broad implications for the future of the country, where the stakes were high and the politics of it all was tearing the country apart. More recently, in the litigation involving refugees who sought asylum here, only last month the UK Supreme Court decided that Rwanda is not a safe third country for the government to send asylum seekers. The decision had broad implications for the 24,000 or so people whose fate hung in the balance. Many had received letters warning that they were being considered for forcible removal. The stakes were high not only for the individuals, but the impact on the way asylum seekers are treated around the world. It's one answer to the question now facing many countries as to whether governments can externalize their refugee crisis by shifting the onus to other countries. There's political polarization and value contestation. Some lauded the court's decision as not only a dream come true for the refugees, but also a victory for those who believe that a core component of British society is that you cannot abandon people in dire need to their fate. But others believe that it is necessary to stop the tide of people flowing into Britain, taking jobs, undermining the British way of life. They could not have been pleased by the decision. Just last week, the government responded by publishing a bill that, among other things, would tell courts reviewing asylum claims to do so without reference to sections of the Human Rights Act and the International Refugee Convention. Whatever one thinks of the merits of the Supreme Court's initial decision, this bill, if it were to become law, would change who the decision makers are on this issue, from the judiciary to the legislature, in that the bill proposes a legislative encroachment on an area now within the aegis of the judiciary. It could be argued that it compromises judicial independence. And there are many cases, either in the courts now or about to be, which will divide people, the results of which may make some people angry, upset, annoyed, but others pleased, happy, convinced that the decisions made were the right ones. For example, 6 British water companies are facing lawsuits for allegedly overcharging customers by underreporting sewage discharges. The suits follow on the heels of public criticism over the dumping of raw sewage. Broad implications. Millions of people who use the water supplied by the companies have a stake in the results. The suits now seek hundreds of millions of pounds. But high stakes, both reputational and financial, as well for the companies who say the claims are without merit. And finally, litigation is brewing over the conditions faced by Liverpool fans on the way to and from the Stade de France for the 2022 Champions League final. Hundreds of ticketed fans who had been corralled into a fan zone were directed to walk to the stadium. Allegations in a letter before action sent to UEFA describe fans being delayed into getting into the stadium in increasingly dangerous conditions, crushed in the crowd, pepper sprayed and tear gassed, hit by riot shields, facing a violent and dangerous situation. The matter has yet to be filed as a complaint, but if it is, there is no doubt that it will be closely watched, not only because 2022 is still fresh in people's minds, but also because the memories of Hillsborough have not faded. If the litigation moves ahead and a judge is assigned to handle it, they will no doubt find themselves doing their work in the midst of a maelstrom of public opinion. So I return to the question of what we can do to uphold justice in an age of uncertainty, to ensure that judges can exercise their function in an independent fashion. And I think we have to look at it through different lenses. There's the question of what can judges do themselves. Draft opinions that are written so people can understand them and which provide cogent explanations of why a decision goes one way rather than another. When a higher court opinion breaks new ground, analyze how deeply the hoe went into the dirt. Be parsimonious in deciding its reach. Understand that often judges are asked to rule on issues that are on the battlefront of public opinion. Avoid entering the fray and eschew polemics. In other words, exercise judicial restraint. Resist the urge to address issues that are more properly addressed by other branches. Don't treat every policy problem as a nail for which a judicial hammer is appropriate. Bear in mind that the principles of judicial interpretation have been developed over centuries, and that humility better serves the judicial task than hubris. Abide by existing codes of judicial conduct so as to avoid even the appearance of impropriety, and if there is no code of conduct, implement one and give it teeth. With respect to the legislature, avoid publicly critiquing judges or judicial opinions merely because you disagree with them on a question of public policy. If you believe a particular judicial opinion is counter to the country's interests or damaging to your constituency, consider whether there is a legitimate legislative way to remediate the damage. And if there is, engage in the political process to try to do so. A political power grab by the legislature or the executive away from the judiciary rarely ends well for the body politic. Budget funds to provide security as necessary to judges when they are threatened with physical attack. If, or to the extent that the selective process for judges has been politicized, depoliticize it. Picking judges who are of your political persuasion may feel good while you are in power, but not so good when another party of a different political stripe takes over. And finally, through the lens of you, the audience, you're doing exactly what you should be doing. educating yourself on the role of the judiciary in a democratic society by attending lectures like this one. I thank you for that as well as for your time and attention.
Thank you, Judge Peterson, for a fascinating lecture. I think your reflections on judicial independence, the threats to it and its significance as a key tenet of our democracy resonate, as you've said, not only in the US and UK, but internationally. I think you've also offered a compelling case for the broader significance of judicial independence in ensuring that as a society we can really meet the challenges that we face. And I think you've also connected the role of the judiciary, our immediate context here at the University of Liverpool, and with national, devolved and local government, all of which, as public institutions, have an important role to play in meeting the significant challenges of the moment and doing so in a way that upholds democratic values and practices. So I'm delighted to say now that we can open for questions. And please may I first come to Professor Balsamis Mislegis, who is Dean of the School of Law and Social Justice here at the University of Liverpool. Thanks, Balsamis.
Thank you very much. Thank you so much for this wonderful presentation, and thank you for choosing to speak about judicial independence. I agree with you that it's one of the main challenges today, for democracies, for liberal democracy, and for the rule of law. And the examples are all pertinent. And I have many legal questions, but I'm going to ask more like a personal, or perhaps political question.
Okay.
Picking on what you said at the end of your presentation, so you mentioned the Rwanda litigation here in the UK, which is a perfect example, I think, of what you were trying to demonstrate, where we have politics, we have political polarization and value division, if you like, but those, the more skeptical between us, think that this is also a veiled attack on the understanding of separation of powers. So we have an attack against the judiciary, by the executive, by the current government, and it's not the first time. You mentioned Brexit as well. So, and just to advertise the seminar we're holding in the law school tomorrow at 5 o'clock on Rwanda. So if you're here on campus, just come to listen to us. But so one might say this is not really about values, whether we think this is right or wrong, or whether more migrants should come to the country or not. But this is really an attempt really to discredit really the judiciary as a legitimate branch of government under the guise of parliamentary sovereignty. That if Parliament has decided something, then this should be it. The Supreme Court said that Rwanda is unsafe, and tomorrow Parliament will be debating a bill that says that Rwanda is safe. So how do we square the circle there, in your view? What would be your advice to the judges, perhaps? And how can we educate the public in terms of these rather obscure questions about, judicial independence and separation of powers, beyond coming to this lecture?
Well, is this on? Okay. If you noticed all the way through my lecture, I never once expressed a personal opinion. Because it is inappropriate for me to express a personal opinion. It was always done through the context of a report says, this may be, but others may think. So it is entirely inappropriate for me as a judge to make a comment on your question, but I think everyone else heard you say what you said.
Touche. That's right.
And so for our second question, please may we come to Jonathan Storer, who's Chief Crown Prosecutor for Merseyside and Cheshire. Jonathan.
Thank you. Well, as a politically neutral civil servant, I'll have to be careful how I phrase the question. I'm interested, you mentioned briefly trust in the judiciary, and that is something that is not necessarily in a highly positive situation in either Britain or America. What more can be done by the judiciary or by civil or criminal justice practitioners to build trust?
Well, what we try to do, at least in my court, is we go out into the city and do civics education in the schools, and we talk to people who are interested in hearing what we have to say. I think what I do personally is when Litigants are before me. I treat them with respect that that is their due. I also do one thing that they don't see, but I think is critical, and I referred to it a little bit in the talk, is we all have personal biases. We have biases we know about, and we have biases we don't know about. So I have been very careful, particularly in the criminal context, if I am in the process of sentencing someone, and for some reason, I just decide I don't like this person. Or I decide I feel empathy for this person. I immediately get off the bench, and I analyze myself, and why do I feel this way? And once I've, almost always, I can say, it's because whatever it is, I figure it out, and then I put that deliberately aside, and then get back on the bench without that particular bias. And so I think as individual judges, that's the only thing we can do. Certainly we are subject to the changes that I spoke about with respect to how the Supreme Court is developing jurisprudence. For a while there, I said, well, just because they want to use that judicial interpretation doesn't mean I have to. And then they told me, no, you do have to. So now I have to. And I was engaged in a discussion with someone the other day who said, well, why do you have to? Why can't you just do what you think is right? And I said, because if I do that, then I break the fabric of society. And I do think it's not just the fabric of judicial interpretation or the fabric of the judiciary. I think I break the fabric of society, and I can't do that. And so even though I may question ways in which I have to do my job, nevertheless, if it is quite clear that that is what appellate courts and higher courts are telling me to do, I have to do it.
Thank you. I think those points that you made about restraint and also about humility, which is where you landed really in your lecture, are really important for us to reflect on in the current political moment, and in some ways seem to be features of democratic practice that sometimes are more in absence than they are in presence. So thank you. We can now open up more widely to the audience. If you have a question, please raise your hand so I can see you. If you can wait for Helen to bring the mic over, and if you could stand and just introduce yourself, that would be fantastic. Claire. Yeah.
I'm not going to stand up. Claire White from Liverpool CBS. We're the infrastructure organisation that supports the voluntary sector. My question is completely irrelevant to that. Picking up on, obviously, highly controversial women's right to choose, changing legislation in America. And I don't understand how we got there, and I don't expect you to explain that. But given what you've just said about having to follow the decisions that have been made and the precedents that have been set, in your opinion, legal opinion, is there a judicial way to claw that back, that decision?
I won't give you a legal opinion, I'll just describe what's happening. So essentially the Supreme Court had decided in Roe versus Wade that there was a right to an abortion, and it had founded that right in a right of, sort of a penumbral right of privacy in the Constitution. And essentially what the case undoing it said is, no, there is no such right. In the United States, there is a United States Constitution, and every state has its own constitution. In many state constitutions, there already is a right to privacy, and there has already been cases that say that right of privacy includes a right to abortion. On the political side, where states did not have something like that in their constitution, Ohio, for example, recently voted to include such a right in the Constitution. So what is happening is there is a big split in the United States. Some states are saying, okay, it's not done on the federal level, so we're going to do it on the state level. Others are saying, well, it's not done on the federal level, and we're going to make sure in the state, Texas, for example, that it is absolutely impossible to have an abortion. So the political process is stepping in to deal with a decision made by the Supreme Court.
Thanks. I think that was a great question, Claire, and probably one that a number of people in the room were trying to ask, what are the tools that are kind of at our disposal in being able to engage in these debates. I've got a question over here.
Hello, Jim Hancock. I'm the Pro-Chancellor at Manchester University, actually, so it's
Good to meet you.
Greetings from down the road. I don't know whether you're going to be able to answer this because of the caution that you put into the first answer, but you did refer to the politicisation of the desirability of the judiciary not to be politicised. Just as an observer of the fundamental problem that I see, but it may not be soluble and it may be linked to the fact that the President of the United States is also the head of state, whereas obviously here we have a separation in the judiciary in the name of the king.
Yeah.
But the Supreme Court and judges' appointments are made by the President, and inherently, as we saw with the Trump administration, the appointment of a number of Supreme Court judges was regarded as fundamentally significant for the future 10, 20, 30 years of judgments in the Supreme Court. If you are prepared to get into this at all, is there any debate about trying to set up some appointment institution for the Supreme Court that is not from the President?
There is no debate about that because Article 3 of the Constitution would not allow that. But that doesn't mean that your question, I can't answer your question in a different way. With respect to the appointment of Supreme Court justices, if you look back, it has always been highly political. And it's just there's never been a time in the United States history where Supreme Court justices have not been political. And if you look at the decisions of Supreme Courts, there's really, and don't quote me on this because I'm not an academic and I really cannot back this up with solid data, but the way I think about it when I look at cases, every 30 years there's a sea change and things change. So I think that is what it is, and we're particularly in a hotbed right now of discussion about that particular issue. On the lower court levels, I think we do resolve that issue. For example, in my state, we had one Republican senator and one Democratic senator, and the district court judges get nominated by the senators, propose someone to the president. And the senators worked it out that if you had a Democratic president, the Democrat got 3 selections, and the Republican got 1, and switched if there was a Republican president, but the other one had veto power. So if you look at my court, we don't have anyone who is what we would call far right in America or what we would call far left in America, because there was always veto power, and it was that way for years and years. Quite apart from that, if you look at any district court judge, district court opinion, most appellate decisions, it is very difficult to determine on reading them what the political bent was of the judge before they got on the bench. Because most cases are, you've got a discrimination case, factually, was this discrimination or not? Can it move ahead or not? Was there was there a breach of contract or not? Should it move ahead or not? And those aren't political decisions. And even when you get to those few where it has political consequences, I think as judges, we try I've had a few very controversial decisions, or sort of one of the decisions that were just on the boundary. And what I have done is, knowing where the law was going to take me, I've couched the decision using the jurisprudential logic of people who would not want me to go there. I flipped it. So if it goes a right-wing way, I'll use left-wing jurisprudence. If it goes a left-wing way, I'll use right-wing jurisprudence. Just a signal that whichever way you do this, it is going to come out in a particular way. So it probably nobody understands that I'm doing that, but I know that I'm doing it when I'm doing it.
Thank you. I think in the lecture and in your response there, I think it's very useful in what feels like very heated political times at the moment that are polarised to take that much longer term perspective, and I think that can be another really helpful perspective for us. I think we've got another question over here.
I'm Judith Farley, a retired academic at the university, and I am not a lawyer. So I feel extremely naive in asking this question. I have been in favour for some time of us having a written constitution, particularly as life has become more and more chaotic in this country, and you wonder what the hell has happened to the country in which I was born and brought up. I don't recognise it anymore. I'm not so sure that we should have a written constitution, because thinking of the Roe versus Wade controversies that are going on in the states, between different states, we would have the same thing with different laws in Ireland, Wales and Scotland now. I'm not sure. Do you think a written constitution would be of any value here? Or are we now at such a state of dissension between us as individuals, within families and so on, nothing really works anymore?
That's a big question. Here's what I think. I think that, oh, wow, I could go off onto a huge thing. So I think that societies are about people standing together. And people have stood together in a variety of ways. And the ways they do it is based on history, on philosophy, on ways of thinking. And there is rarely a society which, even in, I mean, I'll tell you, in America, the Constitution, Revolution, it was built on this tremendous sense of we are not going to be them and we're going to be better. But there was fights then, all the way through the constitutional conventions. The battles that are being fought in the United States now were fought at the constitutional conventions. So it's just what we do as people, and all we can do as individuals is to try, in the context of uncertain times, to do the best we possibly can in the context of the societies we are. And what we do in America is not what we do here, because we come from different traditions. And all we can do, I believe that as an individual, all your job is in this life is to try and make it better. And so you try and make it better in whatever way you can. I know that doesn't answer your question, but it's the best I can do.
I think with the general election on the horizon, it'll be really interesting to see the extent and scope of the constitutional reform agenda with whatever government we have in next. We've got one more question over here, and then we've probably got time for one more after that, so please do signal to me if you've got a question.
Thank you very much. My name is Konstantin Zistero. I'm a professor of human rights law here, and thank you for a very fascinating presentation. I have one quick comment and two quick questions. Everything very quick.
Very
Take the comment.
Very academic.
The comment is really interesting points about historical analogy, and I can see one really clear group of people who would clearly benefit from this method of interpretation. So legal historians will become the most luxurious profession in the whole world.
Well, to respond to that, I think that if there are any British legal historians, and you are young, why not look at every single Supreme Court decision that involves historical analogy, and your career is made.
Absolutely, absolutely. We have hundreds of these. Absolutely. So, two questions. My favorite court is not the Supreme Court of the US. I'm sorry about that. But
My court?
Yes, of course. So my second favorite court is the European Court of Human Rights.
Yeah.
And in Strasbourg, this debate between originalism and living constitution or evolutive interpretation, as we call it, it doesn't exist. It doesn't. Everybody thinks that, well, the convention, which is much younger than American Constitution, should be interpreted evolutively, like from the perspective of modern name conditions. I wonder, why is it so? I know that the system, well, there are different ways of showing restraint and showing subsidiarity, etc., but not this particular debate. Do you have any thoughts on that? And my second quick question, I emphasize quick on that, is about the reform. So basically, you were absolutely right that in Hungary and in Poland, the governments changed the composition of the Supreme Court and the disciplinary sanctions, but they never, well, they very rarely argue saying that, like, we do that because we don't like them. They argue that they're corrupt, that they have, they go too far, etc., etc. My question is a flip on. What if they indeed corrupt? What should we wait for the tide to go back and like new generation of lawyers come? Because once you dismiss a judge, it creates a huge precedent, and it's very difficult to unpick. So, if you can.
Well, I'm going to duck that second question because I think it's a political question, not a judicial question. So there may be folks in this room who can answer it, but not me. The question that I am going to try and focus it on is, you said in the European Court, they don't have these discussions about originalism and what have you. So there is one of the theories of constitutional interpretation that is often discussed in the United States is that we should just be deciding the Constitution based on our understanding of the normative conditions of our society, right? Which sounds great. And what my response to that is, in the 1980s, when I was in England, there was a normative understanding running through society as to what it meant to be Britain. Right? And you could say it because there was BBC One, BBC Two, Channel 1, 2, 3, 4, and everybody listened to the same stuff and all the rest of it. But there's certainly what you could say, this is what British people believe. Putting aside what British people might think now about their society, in America, that has never been the case. Because America has always been a nation of immigrants with very different perspectives. And so I can't say this is the normative view of what Americans think. So you're kind of left in a position where you can't have, there's not one way you can view a constitutional provision based upon what you think the people think. So maybe that's why we have this discussion of originalism, perhaps. I don't know. I mean, I can, if you want to pinpoint it, there was a judge called Judge Bork who was nominated to go to the Supreme Court, and then he was borked, and part of his philosophy, which was then has then crept into the jurisprudence, is originalism. So Bork, the origin of originalism is Bork, and so that was a case where a justice was nominated and then squashed because people didn't like his views. So I don't know whether that was the beginning of what we are in right now, but I think maybe that's what the European Court might be, or what you're thinking about at this point.
Thank you. I think we've got time for a couple more questions. First from Michael, then over here from Tarek.
Thank you, that was absolutely brilliant. Can I take you back to the start? How optimistic or pessimistic are you about judicial independence being upheld? You talked about the risks, you mentioned in many places which is happening. What is your take on the state of play? Should it be alarmed? Should it be not alarmed? I'm quite alarmed, frankly, so maybe you can't answer that.
Well, what I will say to you is I'm a horrible optimist. I'm a horrible optimist. And I don't know how to live without being an optimist.
Maybe a life lesson for us all in that response. So we've now got a question up here at the back. Thank you.
Thank you. I'm a first-year law student at the University of Liverpool. You've spoken about the rule of law and about how the guardianship of it sometimes comes under the legislative branch, which means at times it is reliant on lawmakers. With the current government's aim of minimising the power and influence of the judiciary, surely it's a paradoxical claim to ask judges to not become political with their influence and their jobs on the line at this present moment, such as like the Miller cases. Thank you.
So that, again, is a very political question, but the way I'm going to respond is you have to. You have to not be political. You have to abide by what the role that society has put you in, and that does not involve being political, because as I said earlier, that if you don't abide by that, then you rip the fabric of society.
I was delighted to have a question from one of our brilliant law students, so thank you for being the person who put your hand up then. We've got another question here at the front. Please do signal if you'd like to come into the discussion.
Thank you. Well, that was gripping.
Gripping? I don't... Wow! I don't have... Thank you.
So my original question was around the written constitution, but given the answer that you gave to that, I'm going to ask you a question which I think you can give me a personal opinion on. So what is your favourite writer of courtroom procedurals?
My favourite writer of courtroom procedurals? I know of his book. I don't think I have a favourite writer. I mean, I could say, okay, I can really curry favour. One of my Third Circuit judges, and the Third Circuit judges are those who my opinions are appealed to. There is a judge called Judge Bibas. I love the way he writes his opinions. Judge Bibas.
I was actually going to say The Good Wife. I thought that was where you were going with that kind of question, but I think it's always lovely.
The Good Wife was written by one of my law school classmates who stopped being a lawyer because he wanted to write that.
I absolutely loved it, so I think that was maybe a good, a good career decision. But I think it's always brilliant to have those kind of models in mind of people who write with real elegance and force when you're taking your own kind of professional work. So you've got a question here.
Hi, I'm Katie Johnson. I'm a lecturer in the law school. I'm a big fan of The Good Wife. So I really enjoyed your description of the historical analogy methodology, which I wasn't aware of. Regardless of one's political views that you can have about the sort of policy outcomes of decisions where this methodology is applied, to me it seems like the most compelling criticism of that methodology comes from legal certainty, for sort of the reasons you've described in your case. And I'm just wondering, apart from these sort of high-profile political cases where historical analogy leads to particular outcomes on gun violence, abortion presumably, has that methodology and the uncertainty produced started to penetrate to more sort of mundane legal questions like contract interpretation? Because that seems like the roots perhaps of a backlash against this.
It hasn't, but what I will tell you that in the 1922G context, where it was the first time the Supreme Court says you have to do this, it really impacted on the 1922G stuff, and the Third Circuit, which is my appellate court, also wrote something which destabilized things even more. And there was no, it drove district judges crazy because we didn't know what we were supposed to do, and so some district judges were just writing footnote opinions, you know, saying yes, it's unconstitutional, yes, I'm going to kick this out. So I thought, no, I'm not doing that. So I have in the last 3 months issued 3 opinions which really delve into those issues and really try. Simply because I did not know what to do, and I didn't want to just be writing opinions without fully understanding what was going on. So I took everything from the Third Circuit case and the Supreme Court case and really analyzed and drilled down so that if there's a defendant in front of me, there's this trilogy of opinions, and they will know what I think is supposed to happen. Now, all those 3 cases that I just I wrote in the last few months are all going to be appealed to the Third Circuit and probably to the Supreme Court. But all I can do is say, okay, new way of interpreting. You don't throw out the baby with the bathwater. You look at exactly what they're saying and exactly what it means in a given context. And as you know, because you're a law professor, you construe it narrowly and you understand that it's in a context, and the context has not gone away. And other precepts that were not addressed in those opinions have not gone away. So how do you mesh things, and how do you fit it together so that the new world makes sense in the context of the old world?
Thank you. I think we've come to we've got more. Go on, we'll fit one more in. Just hadn't noticed that one at the corner of my eye.
Thanks. I'll ask a quick question, but it may be a less than quick answer. Andrew Lewis from Liverpool City Council. In the US in particular, a big distinction between conservative judges, liberal judges, extremist or moderate judges. What makes a judge conservative or liberal? Is it their studious understanding of the law that has created that, or is it something in their personal life, or their religious upbringing, or their class, or their ethnicity? Because surely it matters. It matters if somebody's bringing those external factors to their assessment of the law, rather than their judgment coming from the study of the law.
Well, as I said, I think that there's very few cases in the district court and the appellate court levels where any distinction would actually show up. But I think if you think about the Supreme Court level, there is this. I don't want to dig too much into American history. So at the Constitutional Convention, there was two big sort of lines of thought. One was done by this gentleman called Hamilton, and you have seen the musical about Hamilton, and then the other was Jefferson. And Jefferson had a different view. Jefferson's view was America should be an agrarian society with everyone living in their own homesteads, and it was sort of very much its freedom means the freedom to contently live your life. Hamilton wanted to create a capitalist megalith. And he was smarter than everybody else. So he, every time there was a discussion in the Constitutional Convention, he or some other folks that he had brought on board would write long rationales in support of a particular provision, which was more capitalistic than Jeffersonian. And because he had all of these, they are now in one document called the Federalist Papers, and the Madison viewpoint, or the Jeffersonian viewpoint, is not in these clearly digestible papers. There is something called the Federalist Society, from which originalism has been spoken about and pushed through the system, and it's a very strong force in the United States, and particularly in bringing judges to the attention of the president. So I wouldn't say that if you're going to make that distinction, and I don't necessarily accept that distinction can be seen in opinions we write, but if you're going to make that distinction, I would say there's a federalist component and a non-federalist component.
Thank you. So I'll draw the question and answer session to a close. Just to say thank you again for your time this evening and for joining us at the second of our annual Heseltine Institute lectures. Please do stay with us for a drinks reception. It's in the beautiful gallery room upstairs on the first floor. But please may I just take the opportunity to thank Judge Beetlestone again for what I think has been a compelling and interesting lecture, but also conversation, and hope we can continue that discussion over a nice tipple of our choice. So, thank you again.
Thank you.